Good morning. We're here for oral argument on State of Arizona versus Deandra Sherrell Howard. It's our number CR-25-0211. Each side knows you have 20 minutes. You may keep whatever time you wish for rebuttal, but you have to keep your time yourself. So please proceed.
Good morning, Karen Moody for the State of Arizona. I'll try to reserve 3 minutes, but we'll see how that goes. May it please the court. There is no rule of criminal procedure specifically requiring a substitute sentencing judge to order and review transcripts before proceeding with sentencing. The state is in agreement with Howard that a sentencing judge should be prepared, but each case is unique and the amount of preparation necessary will differ from one case to the next. Instead of creating a new rule or creating a standalone claim of failure to prepare, we should return to this court's original approach in cases like this. A sentencing court will abuse its discretion by acting arbitrarily or capriciously, or by failing to conduct an adequate investigation into the facts necessary for an intelligent exercise of its sentencing power. That last category does not give Howard an opening here. The adequate investigation cases, like Greer or Stotts, are due process cases. They require a defendant to show that the sentencing court relied on objectively incorrect information. That is not going to include a dispute over how evidence is characterized by opposing parties, particularly when there's no evidence visible in the record that the sentencing court relied on these characterizations. Instead of relying on the existing case law, the Court of Appeals majority here found Rule 19.4, a rule that explains what to do when a judge who is hearing or trying a criminal proceeding becomes incapacitated. The rule discusses recessing the court, entering an order to continue a trial, continuing or restarting a trial or proceeding, and potentially declaring a mistrial. It does not discuss what to do when there is nothing to restart or continue. The majority pulled out the fourth sentence from the rule, which states, if the new judge believes after reviewing the record that continuing the proceeding would be unduly prejudicial, the judge must order a new trial or proceeding. And from that language, the majority found that it was reversible error when the substitute sentencing judge in this case failed to stop the sentencing hearing, order transcripts, and read the transcripts at the defendant's request.
So is it your position, Counselor, that Rule 19.4 applies, but it was satisfied, so we're done with that and we're moving on to some other line of inquiry?
No, the Rule 19.4 does not apply. The plain language of the rule, read in context, does not apply to a situation where you're not in a position to restart a hearing or proceeding.
Then what do you make of the fact that we didn't adopt the federal rule?
I'm not sure that we can read much into the fact that we didn't adopt the federal rule. We didn't adopt our civil rule either. The federal rule, I guess I don't know that we can read much of anything into it at all.
Well, looking at the language of the rule, an issue that the parties didn't brief and that the Court of Appeals, in my opinion, completely glossed over is the illness or incapacity language, which is obviously a threshold condition for the rule to apply in the first place. And the Court of Appeals looked at dictionary definitions and found that illness or other incapacity, which would seem to refer back to the like category of illness, included physical incapacity and mental incapacity, and then said, oh, and by the way, the cases also include recusal. To me, those are very, very different things. The analysis of the rule that we have includes recusals without any explanation for that whatsoever. So as someone who's looking at the plain language of the rule, I ask you, do you think that that is a basis for not applying Rule 19.4?
I'm not sure that we can distinguish. I'm not sure what the policy would be for distinguishing between an incapacity that occurred due to a physical inability to proceed with the case, or the fact that the judge had to be swapped out because of recusal. However, I would quibble with the majority's finding that it occurred when the first judge hugged the victim who testified at the aggravators hearing. Because if the incapacity had occurred there, the substitution would have had to have occurred there, and then the review of the record would have had to have occurred there. And the majority doesn't address why it skips past.
Well, that seems to be two different issues of the majority was seizing in what you just said on what's the proceeding and considering the entire trial and every stage as the proceeding. And what Justice Bullock was asking about is incapacity, which if I recall it correctly, the Court of Appeals found the judge was incapacitated by the appearance of impropriety, is the way they phrased it. But, it was kind of squeeze it in there. Do you disagree with that? That if this had occurred mid-guilt phase and the judge recused herself for whatever reason, and now you're left with that, would 19.4 require Judge Whitehead, if he was the substitute judge, to review the record sufficiently to make sure he is up to snuff and it can continue rather than starting over?
I think it's hard to come up with a policy reason for distinguishing between the two things. Again, whether the judge was replaced due to illness or whether the judge was replaced.
The effect is the same.
The effect is the same.
The judge is absent.
Yeah, the judge is absent, and we have to determine whether we're restarting this hearing or this trial. I already stated that I quibble with putting it at the point of the judge, I guess, demonstrating.
But what are the judges, even assuming 19.4 doesn't apply, for the reasons that you advocate, that the proceeding for sentencing is a separate proceeding and no judge left in that proceeding. But it strikes me that you have a whole trial and an aggravating phase, and you need to have some knowledge of what went on in order to be able to fairly sentence someone. It's just as a matter, frankly, of due process and fundamental fairness. So what is the obligation of a judge in that circumstance?
I think it's going to be up to the discretion of the judge. And then the due process cases we have look at whether the judge made a factual error or relied on incorrect facts. And that's where the abuse of discretion lies.
Well,
then
let me back it up a little bit,
Yeah.
and I'm sorry, because we're going to end up writing an opinion on this to guide not only to resolve this case, but to guide future cases and future judges on what they should be doing. And so we'll be writing something saying that when a judge is in this position, the judge should do fill in the blank. And so could you fill in the blank?
I don't think that this court should write a specific rule that says exactly what a judge should do, and that it'll be up to the discretion of the trial judge who is substituting in. And then I know this is going to seem unsatisfactory. The abuse of discretion comes into play when we actually see what the judge says he relied on in sentencing, or if the judge makes an error of fact in sentencing.
So here, if we agree with you, and I appreciate the measured tone of your supplemental brief, especially page 1, where you note that in the Court of Appeals, the parties agreed that a substitute sentencing judge must adequately prepare, and that a judge who fails to do so may abuse his discretion. So if we agree that Rule 19.4 does not apply, but that abuse of discretion and due process are implicated, should our disposition be that we remand it to the Court of Appeals to consider what Howard actually did argue in the Court of Appeals, rather than the detour that the Court of Appeals took?
Yes, the state would definitely agree with remanding to determine it, make the determination based on the arguments that the parties made in the Court of Appeals, which was the due process cases and the Code of Judicial Conduct.
With respect to what the chief asked you about what should we say in an opinion to instruct judges in this circumstance, wouldn't we simply refer them to Stott and say, don't abuse your discretion, conduct an adequate investigation into the facts relevant to sentencing?
Yes, I think we have Stott, we have Greer, we already have the case law that would apply here. And I mean, I would argue, as I did originally in my original answering brief, that the defendant hasn't met the burden of showing an error under Stott's or Greer. I do want to talk a little bit about the rule that defendant suggested in her supplemental brief. At first glance, I'll read it out loud just so that we have it. When a judge who does not preside over trial is called upon to impose sentence, the judge must become sufficiently familiar with the record to exercise informed discretion. And where the facts relevant to sentencing are materially disputed, that requirement ordinarily demands review of the trial transcripts, the FTR, or other equivalent portions of the record. At first glance, that seems like a measured rule. However, that rule still relies on Rule 19.4, which the state's primary argument is that it doesn't apply. That rule doesn't have support in any other rule of criminal procedure or in the due process cases. And I would argue that using the phrase "and where the facts relevant to sentencing are materially disputed" as sort of the trigger for when you look past what the court actually said at sentencing and look into its preparation would mean that you're always skipping past and looking at the court's preparation, because there is always going to be a material dispute of fact at sentencing. In this case, I think amicus raised the dispute of fact as being that the defendant argued that she acted in self-defense. I would argue that that is foreclosed by the jury's verdicts. But there may be other disputed facts that the jury heard where we can't tell what they felt based on their verdicts or how they felt, whether they believed this person or that person or credited this testimony or that. And so there will always be something for a defendant to raise at sentencing or before sentencing that is a dispute of fact. So I think this rule is not as measured as it looks.
Isn't it incumbent upon the defendant to make specific allegations as what the deficiencies are to raise this type of issue? Or otherwise, the reviewing courts are left kind of swimming as to what are they arguing? And here, although counsel in his defense counsel in his supplemental brief talked about the defense specifically identified factual inaccuracies, when I look at the record, at the initial setting of the sentencing hearing, the trial judge said, "Hey, if you want me to look at the record, I'll look at the record." No one asked him to. Right. Defense didn't, the state didn't. And then at the sentencing, at the eve of allocution, the parties presenting their positions, that's when defense counsel said, "Hey, I think something's a little off here. I think there's liberty's been taken in describing the evidence. I think it's fundamentally unfair." That's pretty broad. That's not the specificity I think is required by our case law under your analysis under Greer and other cases. So isn't it incumbent upon the defendant to state specifically what the problem is?
I would think so. And I think the defendant was given the opportunity to do so at sentencing. And the three arguments at sentencing were quibbling with the state's characterization of the facts about what happened between when her uncle got the purse and they ended up at the gas station, whether she was hunting him down. That was a quibble. And then the question of, the defense argued that she suffered from PTSD, and the defense argued that her, I guess, defendant's use of a cell phone during, I think the aggravation phase was not her showing lack of remorse or something like that. The first one would be the closest to an argument in that, like what you're asking about, but it still is just a quibble about the characterization of the facts that are in evidence.
And I agree with that, but maybe to my larger point, it was done during the sentencing proceeding itself, not in some pretrial motion, not in some pretrial paper saying, "We have a problem here, Judge, and we want you to look at this." I mean, the train has left the station here. And now it seems like the defense is saying, there was the judge did something he should have done, but it's really after the fact.
Right. And it would have been, and I would argue that we still don't have an explanation of what an incorrect fact was that the court relied on, which is what's required by Stotts and Greer.
Well, at what point should the defense counsel have spoken up? Then Justice Bean was saying, well, shouldn't they have filed a motion or whatnot? We got that sentencing memorandum the night before sentencing. So I'm kind of wondering, in your view, what should defense counsel have done to bring this to the judge's attention?
It sort of depends on which argument we're in. If we're talking about Rule 19.4, which still the state argues it doesn't apply, I think if that was a mandatory duty, the state or the defense could have raised it 2 months ago when the court asked. If it's a question of a disagreement with what the state put in its sentencing memorandum, I think right then they could have said something, but they would have had to explain what the factual error was.
So the problem is not so much they didn't bring it up, they just didn't bring it up sufficiently by pinpointing, well, precisely what's wrong. And the judge did say something like, you tell me, I'll rule on objections, I'll hear your side, I'll hear their side, that kind of thing.
Right. I think that the judge said that he would weigh it equally, but in the end, we didn't get an incorrect fact. The defendant didn't state an incorrect fact anyway.
And I have a question about going back to Stott and the adequate investigation. I know you referenced earlier if there's a factual error at sentencing. And I'm wondering if, and I know it's your position that wasn't the case here, but in terms of delving into this adequate investigation portion, I'm wondering, would that include any misstatement, like if a sentencing judge has any misstatement of the record from the guilt phase, or does it have to be some sort of material factual error, factual misstatement of the record from the guilt phase?
Well, Stotts would also say that I think it's Stott that says that the court also has to rely on the misstatement, which I think would mean it would have to be a material misstatement or material to sentencing and visible in the record that the court relied on it. Does that answer your question?
Yes.
Okay.
So it's your position then that there's been nothing pointed out, no misrepresentation of the record on which the trial judge relied in sentencing?
Correct. Does anybody have another question? With that, I'll reserve my 2 minutes.
Thank you.
Okay, thank you.
Good morning.
Mr. Johnson.
My name is Stephen Johnson, and I represent Ms. Howard. Mr. Steinfeld is also here. He is also going to be sharing this argument, but we will keep track of when it's time. I think we can find a good time to switch. What we're not asking for in this case is a bright line rule going forward. I think there are some unique circumstances in this case that separates it. So I represent Ms. Howard, and what we are asking for is, in this case, the defense said, are you going to read the transcripts? And the judge said, no. To be fair, the judge said, I will if you want me to. Then the night before sentencing, the defense attorney gets the sentencing memorandum, comes in and says, took some liberties, which is a nice way of saying, there's some discrepancies, there's some problems with this. And the judge says, well, yeah, but I'm still going to go forward. You can argue with me, but the judge wouldn't know. And to be fair,
Practically, counsel, doesn't that happen at just about every criminal sentencing hearing? As a former criminal trial judge, the parties are still arguing about the facts and how much weight the judge should put on the facts when meting out the sentence.
absolutely. And as someone who has done criminal, you would have known about the facts of the case going into the sentencing. We're saying in this case.
But also, Judge Whitehead said he got up to speed, and he outlined at the sentencing hearing what he read, the psychological eval, the 21 letters, and other things that he listed on the record. And Defense counsel didn't make an objection that wasn't enough at the time.
He did come in, the defense counsel did come in and say, we have some discrepancies. Are you going to read the transcripts? You know, it's like reading the cliff notes of a book without reading the book. To say, yes, he read the psychological evaluation, but Judge Whitehead didn't know that there were 3 swings and that the victim stepped towards the defendant, didn't know the specific facts to know the case adequately. That's our bigger issue, is that whether it's 19.4 or due process, the judge needed to be familiar, and there isn't a valid reason why not to read the transcripts. We're not saying every case you have to read the transcripts. There are certainly some cases where it's possible you don't have to be completely up to speed, but in
Counsel,
this,
but correct me if I'm wrong, that we've established that there was not a request from the defense to read the transcripts.
there was a question, that's true. There was a question at the first hearing saying, are you going to? The judge said no. And then at the second
He didn't
hearing,
say no, he said,
I will
if you want me to.
That's fair. And then at the second one, after the defense counsel gets the sentencing memorandum and realizes there's some discrepancies, then comes back and says, this is unfair. This is what, in essence is saying, there was a problem here. We need you to read the transcripts. It doesn't use those words. Can't stand here and say, defense counsel said, stop, read all the transcripts. But the judge, who was a criminal judge who's been doing it a long time too, is now hearing actual discrepancies, factual discrepancies.
I think I'm looking at the right quote. I think some liberties were taken at describing evidence and such, and I think it's fundamentally unfair if my client gets sentenced by a judge that did not have the benefit of having sat through a trial and knowing what is accurate and what is not accurate. You take that as a request to read the transcripts?
Yes, to say that we have an issue here. There are discrepancies.
Well, no, it's saying it's fundamentally unfair that he's being sentenced by someone who didn't go through the trial. But there's no request that there be a reading of those. I mean, you can interpret it that way, I suppose, but there's not a direct request for that.
No.
And there's not a request for continuance either, right?
No, they go forward and the judge says, well, here, both of you. And our position is that's not how it should have worked. There should have been a break. There should have been a reviewing of the FTR
Right.
transcripts.
And to Justice Bean's point, it happens unfortunately often that at the last minute, and should not happen that way, especially in a case as serious as this, that one is reviewing pre-sentence reports so late in the game. But when it does happen, then isn't it incumbent upon the defense to say, let's stop, we have a major issue here, we need to fully brief it, we need you to read these portions of the transcript that address our concern.
Justice, ideally, that would be the way it should have happened. In this case, it's still incumbent upon the judge to be adequately prepared for the sentencing. And when the judge hears there's discrepancies and the transcripts should have been involved, I just don't know why the judge didn't read the transcripts of the FTR to be prepared after a long trial like this.
Well, could it be because he didn't have any specific points to look for? I mean, he didn't have any specific portion of the trial transcript. So you're saying he should have read the entire trial?
In order to become adequately prepared, he should become, I can't say read every page, jury selection or anything like that, and that's why we're not asking for a bright line rule in here if one judge takes over for another. We're talking about the specific facts of this case. And in this case, once the combination of the sentencing memorandums came in and then the defense attorney said, wait a second, there's liberties being taken, that should be enough for a judge to realize I need to know the facts of this case better.
Right, but having done that work specifically, having been on the trial court and done many trials and sentencings, I would have wanted to know from the defense, what is the unfairness? What is it? What is the point? What part of the transcript do you want me to look at?
Agreed, and the judge should have said that instead of saying, well, here, both of you, and then I'll just make a determination.
And if a defense attorney simply says, this whole thing is just unfair, then there's not a whole lot that the trial judge can do with that.
We would love to go back and have defense attorneys say what we want them to say. That's all appellate.
Don't you at that point waive because you're saying, this whole thing is just unfair, and just kind of sigh, which happens.
It doesn't just say it's unfair. Unfair and couples with there are discrepancies. There are a polite way of saying lies in the state sentencing memorandum. It's not
Wasn't
just
it the
simply that this
duty, though, of counsel to indicate in some way what those discrepancies were? specifically regarding who advanced on whom. That's contained in the transcript I understand you may not have had the transcript at that point, but this is a disputed area, Judge. It may be important in your sentencing, even though the jury found 3 aggravating factors. Can we brief that for you, what the record actually said and what their memo says it said?
Correct. Yes, it should have, would have. Yes, that would have been ideal. I don't think we'd be in the same position if we had done that, but I don't think we'd be in the same position if the trial judge had just adequately prepared for sentencing. They took over a trial, not a change of plea. But yes, would it have been better for the defense counsel to say, I have these 3 issues and I would like to brief them? Yes, that still doesn't change the underlying fact that the judge needs to be adequately prepared.
What does it mean to be adequately prepared in your view? I mean, does it mean you have to read, you alluded to this a little bit,
Right.
you read everything like jury selection and such, but so what do they have to do to become adequately prepared? I mean, at this point, I assume the transcripts aren't even prepared from the guilt phase.
No, but the FTRs are right there.
So you had to sit down and watch all of the FTRs from beginning to end of the entire trial?
I believe it's case by case, right? And I believe in a case like this where it was a murder trial that did last, I believe it's a 7-day trial. But I think it is incumbent upon a trial judge to be prepared to go forward. So in this case, again, I don't want a bright line rule going out from here because then everyone's going to say, Mr. Johnson, what are you doing? But to be adequately prepared for a sentencing, in this case, especially after you found out that the sentencing memos there was some confusion and then the statement. In this case, I think Judge Whitehead should have gone back and reviewed the FTRs.
Does the fact that the state asked for a maximum sentence, but the judge imposed a lower but still aggravated sentence, does that calculate into the determination of whether the judge was adequately prepared? Is there any sort of relationship there?
I don't think so, because the reality is we could go through all this, you could grant us a new sentencing and she could still receive the same sentence. But at least at that point, the judge would have been adequately prepared to hear all the facts and then to hear the sentencing. The fact that the judge just decides, I'm still going to give a person who had no prior felony convictions, talks about PTSD in an aggravated term, but just not a the max. I don't think that changed the fact that the judge should have been more prepared for this.
So, or did I mean, perhaps I'm misunderstanding.
Sure.
You're saying if the judge had reviewed the record and in spite of the defense challenges to his characterization and conclusions about what happened at trial and issued precisely the same sentence, there would be no appealable issue? No prejudice, in other words.
Oh, so if the judge had prepared for this, so if the judge had read because you can take FTRs and you can have them transcribed, maybe not as an official transcript, but if your position is, had they been prepared, had Judge Whitehead read the transcript and everything, came in and made the decision, I don't think I can stand here and say that either 19.4 or due process, you can still appeal other issues, but I don't think you can appeal that issue because the judge is prepared.
But what is the judge looking for? I mean, because the judge, we can tell judges, you're going to read the transcript of the trial. Anytime you're going to sub in a sentencing, you're going to read the entire transcript. Okay, read. If you don't have an issue pinpointed by the defense, what is the value of reading the transcript?
If Judge Ryan Tuhill had done the sentencing, Judge Ryan Tuhill would have known everything was going on. So when she then read the sentencing memorandums and read, oh, there are some discrepancies, she would have read the book. She would have known when the state comes in and says there was no third swing or there was no self-defense. And the defense says, yes, there was, because she was prepared and had seen the trial. Or if Judge Whitehead had read the FTRs, he would be able to say, oh, that's not how I read that at all. He never took the time to become even conversant with what happened with the actual facts of the case beyond a pre-sentence report and 2 memos. And I don't want to take all of the time for Mr. Seinfeld, so unless, okay.
Good morning, Michael Steinfeld for AACJ. I think we're having an interesting discussion about preservation and timeliness, but we're not actually grounding it in the language of what's required. And so going to Justice Bean's questions that have to do, I think, with the timeliness, I think it's important to recall that in Perez Gutierrez, this court said that an objection is timely if it affords the trial court an opportunity to correct any error and avoid an issue on appeal. Now, in this particular case, then, I think the timeline is crucial. Because remember, we have a July 11 proceeding at which Judge Ryan Toohill is planning to proceed with sentencing. Then the conflict occurs after that, or the bias finding occurs after that. Then in August, on August 30th, Judge Whitehead indicates that he's probably not going to read the transcripts. It's then on October 25th, the afternoon before sentencing, that the state submits its sentencing memorandum. At the very first opportunity when defense counsel saw that there was a potential misrepresentation, defense counsel brought it up. Sentencing had not started at that point. This is on pages 3 and 4 and 5 of the record for that transcript. And so this was literally the earliest time that it could have been done. And this is where I think we then get to specificity, Justice Cruz, because when it comes to specificity, this court said in Dietrich that the purpose of making a record is to give the trial court an opportunity to consider and rule upon the position advanced by the party. There's no magic words requirement, and I think this court understands that. But when it comes to this idea of there was no request for transcripts, I agree that if we look at the sentence that you pointed out to, Your Honor, it does seem like there's not an express request for that. But I think you have to recall that prior to this, the very, preface to getting to this argument was, Judge, recall, we had a meeting in August when you said you weren't going to read transcripts. And it's at that point
I want to make the record clear here that that's not what Judge Whitehead said.
Yeah, fair.
He said, if either party thinks that this is necessary, let me know, and I'll certainly do that.
And I agree with you. And that's what was being done before sentencing occurred, is because of what the state said in their sentencing memorandum. Defense counsel was bringing it up and indicating, Judge, you previously indicated that you weren't going to read transcripts. I am now of the opinion that that would be fundamentally unfair to proceed in that manner. Not only that.
Because why?
Because of why?
What was the fundamental unfairness?
So I think the interesting thing is when we actually reflect on the record, we're going to have to go a little deeper. And the reason is because the conversation, Judge Whitehead didn't ask, what's actually the fundamental unfairness? What are the problems? But when I then look at the record, Your Honor, there are a couple of things that stand out to me. The first is the hunting allegation, and then the second is the reliance on the testimony of Mark Aronov. I'll take them in reverse order. As to the statements that Mark Aronov allegedly said, the state put a lot of heavy reliance upon Mr. Aronov's statements in their sentencing memorandum. And then on page 31 of the transcript for sentencing, defense counsel pointed out that they had essentially attacked the credibility of Mr. Aronov, that they had pointed out that he was a heroin addict, and that he even indicated that he didn't have appropriate memory. The second thing I think is the more important one, though, which is the hunting. Because the state on 2 pages, page 3 and page 9 of their sentencing memorandum, accused Ms. Howard of going out hunting. And here's why it's uniquely problematic. They made the same argument during the Rule 20. And defense counsel said, I don't think there's any evidence of hunting. And Judge Ryan Toohill agreed. That's on page 98 of the May 10th, 2022 transcript. The court said, well, a few things. One, I agree with you. I don't recall hearing any evidence that defendant went hunting for the victim. This entire hunting claim that was reintroduced after Judge Ryan Toohill made that ruling, after Judge Ryan Toohill was conflicted off, and after Judge Whitehead indicated that he was not inclined to read the transcripts unless expressly requested, the state reinserted that argument.
Defense counsel brought that up, at least in the argument, and said there was no cruising, there was no hunting.
Yes.
That's what the state wants you to believe, but it just didn't happen. Just because they want it to be so doesn't make it so. I mean, so it was brought up to the judge's attention and such. So, I mean, doesn't that make a difference?
And then on page 47 of the same transcript, Your Honor, the judge said, we as a society don't allow vigilantism for any reason. The court endorsed the hunting narrative. The court endorsed the idea that this was vigilantism. That's the fundamental problem here. And ultimately, what we're really talking about here is we're talking about a uniquely different standard because we're talking about the due process standard, which is under Greer, that imposes the burden upon the defendant to prove that there were inaccuracies. That record on its own proves that. But here's the interesting thing. Our rules are also intended to enforce those rights and sometimes require that courts do things without necessarily then carrying the same sort of responsibility. If this were a due process claim, I would argue that alone is sufficient to establish the due process violation in this case.
On the vigilantism, I read that, and I don't know that it really equated to the hunting claim. I mean, I think what the judge was, what he went on to say, it was that you were looking around and you found the people, was you got out of the car instead of just simply dialing 911 saying, hey, I see these people. You got out of the car and confronted them on your own. I think that was the vigilantism. I don't know that that really translates into the hunting. So that he adopted that idea, as you say. Is that a bit of an overstatement?
No, I don't think it is an overstatement, but the reason I don't think it's an overstatement is because I like it. Fundamentally, I see your point, Your Honor. And I don't think, though, that when we're analyzing the question of reliability and whether the court has relied on something that may not be unreliable, we look at it from the perspective of like, can we hypothesize a way in which this doesn't line up necessarily?
And here's my point in bringing it up, because I do think that, I'm a bit disturbed that defense counsel didn't bring up, here's what I want you to look at, the hunting or the Mr. Aronoff's testimony or whatnot. He did bring it up, though. I would think it'd be incumbent on the judge to think, does this matter? Does this matter to me? And if it matters, like the hunting, then yes, I need to go back and look and see what precisely was said here so that I have a good idea. But I didn't see an indication that those things mattered in the end from what he said.
The reason I would say that it does matter actually goes to Justice King's question about the aggravated sentence, because we have a scenario here where that vigilantism played part of the role in why it was the court imposed an aggravated sentence. And the other thing that I would posit to Your Honor is that notion of vigilantism in many ways is actually inconsistent with the verdict, because the verdict here was not murder second as charged, but the lesser of manslaughter on sudden quarrel or heat of passion. And what that actually means then is that in many ways, the jury kind of bought the self-defense claim. It was an imperfect self-defense claim, if you will. And so this hunting versus imperfect self-defense then becomes crucial when trying to decide the culpability of Ms. Howard.
Well, and to Justice Bullock's earlier question some time ago, is the answer then simply, if we don't agree with the 19.4 interpretation, to send it back to the Court of Appeals to resolve the arguments that were made on that issue about whether there was a due process violation?
I would agree with that, but let me try to convince you not to ditch out on 19.4, because I think fundamentally we also need to look at what 19.4 does and why it's there. It's the only rule that allows for the substitution of judges, which means it has to apply in all circumstances where we are substituting judges. If we actually take the state's argument about proceeding and how we define proceeding, what that even means then is that the substitution of Judge Ryan Toohill wasn't appropriate under their reading. And what it does then is it sets out a process, and in the fourth sentence, it sets out a responsibility. And under Larios, which is a Ninth Circuit case applying Federal Rule 25, the scope of that responsibility varies depending upon the case. Thank you.
Thank you, Mr. Pleitfeld. Okay, Ms. Moody.
Okay, I'd like to start with, here in the Supreme Court is the first time I'm hearing that the alleged misstatement is based on Aronoff's testimony and the fact that he was cross-examined. Aronoff's statements are in the record, and we don't know how the jury credited them. And the fact that they were disputed at trial does not give you an opening to go then argue that you have to go review the transcripts, particularly if it wasn't pointed out to the trial judge in the first place. It's in the record, and it is so not an incorrect fact. Another issue that comes up is the question of whether there was a third swing or whether she acted in self-defense. The jury actually did resolve the self-defense question. They rejected self-defense. The jury did hear evidence of hunting. After Ms. Howard testified, she was cross-examined by the state, And the state brought in evidence of her statement to the police where she said something along the lines of, my uncle, I wish I had brought that with me, my uncle told me where they were, and so I followed.
What about, if you could just quickly address Mr. Steinfeld's final point, which I picked up on as well reading the transcript, that Judge Whitehead really seized on this idea of vigilantism. And I thought, well, wait a minute, she got convicted of provocation manslaughter. So they didn't buy that she had any kind of intent going in to I suppose, harm this individual, but certainly got into some kind of a heated discussion and then was provoked, and then that's what happened. So doesn't that indicate maybe that the judge was not sufficiently informed?
I don't think that the jury's finding that it's sudden quarrel, heat of passion, manslaughter forecloses the statement that Howard acted, that Howard carried out self-help, acted in a vigilante style. She, in that moment, whether she hunted them down or not, in that moment, chose to get out of her car, armed with a weapon, and demand her purse back. And that can be sudden quarrel, heat of passion, because of the circumstances that led up to that moment. But it was still vigilante justice. And that is what the court, and that was not a disputed fact. Her own testimony admitted that she got out of the car and she confronted him. So that was not really even a disputed fact anyway. So it was proper for the court to rely on it. Thank you.
Thank you, counsel. All right. Thank all counsel for your arguments today and the briefing. We will take the matter under advisement and issue a decision in due course. We stand adjourned for the day.